suspect. Let me remind the jury of the burden of proof. The prosecution must prove that, beyond a reasonable doubt, Avery Becker was at Mr. Brackman's house to break in to trash his house, and that he died while Mr. Becker was in the house. Garbage in, garbage out. Thank you.
Thank you. I have just been advised that the meeting is now streaming live on custom live streaming service. Does that answer your question, Ms. Kiefer?
Yes, Your Honor. Thank you.
Thank you. All right. First witness for the people, please.
Excuse me, that took me a second. I'd like to call Detective Markowitz to the stand.
Detective Markowitz. I won't swear witnesses in again because all witnesses have already been properly sworn. You can proceed, Mr. Patel.
Thank you, Your Honor. Hello, Detective Markowitz. My name is Callan Patel, and I'd like to ask you a few questions about your work on this case.
Okay.
Please state your name and spell your last for the record.
My name is Jordan Markowitz. Markowitz.
And are you currently employed?
Yes, I'm currently employed with the Denver Police Department, or the DPD.
And what do you do for a living?
I'm currently working with them as a homicide detective.
And how many cases have you dealt with as a homicide detective?
Hundreds.
Have you received any specialized training as a homicide detective?
Yes, I have received tons of special training. I've received training in,
excuse me.
I'm sorry.
Continue.
Thank you. I've received plenty of specialized training. I've received training in types of cell phone tower data and records and how to obtain both of those. I've learned about forensic software data and using that to download information, acquiring and interpreting cell phone tower records, and obtaining and interpreting cell phone tower data.
And do you use this training regularly?
I use this training constantly.
How many cell phone cases have you worked with?
Easily over 50.
And have you ever testified as an expert witness before?
I've testified as an expert witness many times.
And in what types of courts?
Federal as well as state.
And in what states have you testified in?
Mostly here in Colorado.
At this time, the prosecution moves to admit Detective Markowitz as an expert in the field of criminal homicide investigation and cell phone and tower analysis.
Any objection to the detective being admitted as accepted as an expert in the fields in which she was tendered?
Yes, Your Honor. Permission to voir dire.
You may voir dire as long as it goes to qualifications, Ms. Burnham.
Okay. Detective Markowitz, let's talk about your education.
Okay.
First, in your affidavit, did you state where you went to college or where you received your degree?
That is not in my statement, but I can answer it if you'd like.
No, thank you. So you didn't think that where you got your education was important enough to your credentials so as to add it to your statement?
No, but like I said, I will answer that question if you would like me to.
I just want to know whether or not you put it in your statement.
It is not in my statement.
And is it true that your cell phone data training course was only 3 days long?
Followed by a certification test.
Your Honor, the defense objects to Detective Markowitz, I apologize, being entered as an expert in the area of cell phone data recovery due to lack of education in this area.
Response?
Your Honor, the certification test speaks to her knowledge about the skill rather than just how much time she spent learning this thing. She passed the certification test, which clearly makes her qualified in the areas of cell phone and cell tower analysis.
Any reply, Ms. Burnham?
The defense maintains that 3 days of education is not long enough to fully qualify this expert in the field of cell phone data.
Because it would completely torpedo the prosecution's case, I'm going to allow Detective Markowitz to testify as an expert. Recognize, just parenthetically, that most of what you talked about, Ms. Burnham, went to the weight to be given her testimony rather than the admissibility of her testimony, which is what voir dire focuses on. But on your side of the equation, Mr. Patel, you're stretching it to call this person an expert, but you didn't hear me say that. You can proceed, Mr. Patel.
Thank you, Your Honor.
The objections,
Detective Mark,
pardon me, Detective Markowitz will be accepted as an expert in the field in which he was tendered and permitted to give opinions. You can proceed, Mr. Patel.
thank you, Your Honor. Let's talk about your involvement in this case. How were you assigned to this case?
I was assigned to this case on March 6th of 2020 by my boss.
Okay. And where did this crime occur?
In Denver County of Colorado.
And what was the date that the crime occurred?
This crime occurred on the same day I was assigned to it, March 6th,
Okay.
2020.
Did you ever visit the crime scene?
Yes, I visited the crime scene the day of the crime.
Okay. And if anything, what did you observe when you first arrived?
When I first arrived at the scene, I noticed that the front door of the house was open. Just inside of the front door was the victim, face down in a pool of their own blood, with a visible stab marking in their upper left shoulder.
Were you able to identify the body?
Yes, I was able to identify the body as the body of Mackenzie Brackman.
And was there an autopsy performed in this case?
Yes, there was.
Okay. And what was the conclusion of that autopsy?
The conclusion of the autopsy was that the victim was stabbed in the upper left shoulder and that the knife, when he was stabbed, punctured his aorta.
And when you arrived, was there anyone else on scene?
When I arrived, there were paramedics as well as police officers at the scene.
Anyone after you arrived?
Upon my arrival, I called my forensic team, as I do in every homicide case, and so they arrived after I did.
Okay. And what did this forensic team do at the scene?
I asked them to take photos of everything that was relevant to the case.
Your Honor, may I constructively show opposing counsel and witness what has been previously marked as Exhibit 4?
You may.
Thank you. Is it up?
I do not see it yet.
1 second. See if I can fix one thing about that. There we go.
Perfect.
We're up.
Okay. Detective Markowitz, what is Exhibit 4?
Exhibit 4 depicts the body just as I saw it. The victim is face down, just inside of their front door, with the stab marking in their upper left shoulder, and a large pool of blood, and their shirt is soaked in blood, which just goes to the amount of blood that was.
Okay. And is this a true and accurate picture of Mackenzie Brackman's body when you arrived on scene?
Yes, this is the body just how I saw it.
Okay. Your Honor, at this time, the prosecution moves for the admission of Exhibit 4 as its accuracy has been shown and authenticity stipulated to.
Any objection to 4?
No objection, Your Honor.
4 is admitted. Next question, Mr. Patel.
All right. Thank you, Your Honor. Did you observe any blood at the scene?
Yes, I observed tons of blood. Not only was there the blood that is shown in Exhibit 4, soaking his shirt and the floor surrounding him, there was blood on the knife, that was the murder weapon. Then there were also blood drops leading from the place that he was stabbed, as well as blood spatter on the walls and ceiling.
Pardon me for interrupting. Is there a reason that Exhibit 4 is still up?
Not anymore. Sorry.
All right, let's take it down then. Thank you.
What does this blood show?
Which blood are you referring to?
Sorry, the blood drops.
The blood drops depict Mackenzie Brackman's path from where they were stabbed to the front door.
Okay, and are there any photographs of this blood spatter or blood drops?
Unfortunately, there are not photographs of the blood spatter or the blood drops.
Why is that?
That is because those photos were unfortunately corrupted. We did have photos of them, but currently they're not recoverable.
And what do you mean by corrupted?
I mean that as far as my knowledge goes, we do not have those photos at the moment and cannot obtain them.
Let's talk about your assessment at the scene. Do you know what a ring security is?
Yes, I do. And I observed Ring cameras at Mackenzie Brackman's home.
What is a ring security?
A Ring security camera is a doorbell, or they also have motion sensors. So the doorbell was at the front door. And there is a doorbell that as soon as it senses motion, it begins to take a video recording of the motion that it sensed.
And did Mr. Brackman have this system?
Yes, he did. He had 3 cameras. He had the front door camera that was also the doorbell. And then he had one by the back gate and then another one by his back door.
Okay. And were you able to view this Ring camera footage?
Yes, I was. I used Mr. Brackman's account and I viewed all of the footage from the day of the murder.
Perfect. Let's move on. Excuse me. Was the person the same person in each Ring video?
Yes, I found the videos of the time that he was murdered, and I noticed that it was the exact same person. And you could tell that because they were wearing the exact same mask, the exact same clothing, and the exact same gloves.
And were there any physical similarities between the intruder that you saw in the Ring videos and anyone involved in this case?
Well, the defendant, Avery Becker, has an approximate same body size as the person that was in each of these videos.
And did you have any initial subjects or suspects after leaving the scene?
Immediately after leaving the scene, I did not have any suspects. However, I did have a lead.
What was that lead?
That lead was the mock trial team. The deceased was wearing a shirt that said "Keep Calm and Mock On," which led me to further investigate into that.
And did you reach out to any of the mock trial team?
Yes, I reached out to Mr. Cifuentes.
And what, if anything, did you learn from talking to Mr. Cifuentes?
I learned of Miss Becker, the defendant.
Your Honor, may I constructively show opposing counsel what has been previously marked as Exhibit 14 for identification?
You can do so.
Thank you, Your Honor.
I see them, counsel.
Okay. Detective Markowitz, do you recognize the document in front of you?
Yes, I do. These are the screenshots as I received them from Mr. Cifuentes.
Are these text messages accurate?
Yes, they are.
Complete?
Complete.
And truthful?
Very truthful.
Your Honor, at this time, the prosecution moves to enter Exhibit 14 into evidence as its authenticity has been stipulated to and accuracy shown.
Any objection?
No objection to the screenshots being entered, Your Honor.
14 is admitted. Next question, Mr. Patel.
Okay. Thank you, Your Honor. Did you try and interview Avery Becker?
Yes, I did. And we actually had an interview set up. However, a little bit before the interview, I got a call from the defendant's lawyer saying that the defendant would not be coming in for the interview and that all further contact must go through the lawyer.
Did you undertake any other investigation of the defendant?
Yes, I obtained the defendant's cell phone tower records.
And what do these records show?
These records show that the defendant was at Mackenzie Brackman's house at the time of the murder.
Based on your investigation, detective, did you come to a conclusion as to who murdered Mackenzie Brackman?
Yes, I did. And my conclusion was that Avery Becker, the defendant, is who murdered Mackenzie Brackman.
Did you conclude what the motive was for this crime?
Objection, Your Honor.
What's the objection?
Speculation. The witness does not have personal knowledge of the mental state of Avery Becker.
You can, pardon me. Any response?
Yes. It is the witness's expert opinion as to what their own conclusion was for the motive. I'm not asking what the motive was, rather what they concluded the motive to be.
Response?
That still requires the witness to speculate as to the motive of the intruder.
And they're allowed to speculate as they're an expert witness. Excuse me. Sorry,
Oh.
Your Honor.
What rule is that, Counselor, that allows an expert witness to speculate?
I don't have it pulled up with me right now.
Well, I'm
They're
not, with all due respect, Counselor, I don't know of any rule of evidence that allows any witness to speculate. I'm going to sustain the objection, but on the grounds that there's insufficient foundation for the testimony. If you want to lay more foundation, Mr. Patel, you're welcome to proceed to see if you can do that. And let's take Exhibit 14 down if we're done with it, okay?
Yeah.
Thank you. Back to you, Mr. Patel.
Is your opinion within a reasonable degree of certainty?
Yes, within a reasonable degree of certainty, I can conclude that the defendant killed Mackenzie Brackman.
Okay. That is all, Your Honor. Thank you.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon, Detective Markowitz. Today I'm going to be asking you some questions about your involvement in this case.
Good afternoon.
To begin, is it true that you say in your statement that the slight disarray in Mr. Brackman's house could have been nothing out of the ordinary?
Could have, or it could have been that a murder was committed at the home.
But it's possible that this was just the normal state of the house.
It's possible, but that wouldn't really explain the broken plate on the ground.
Right.
But could.
And you also say that expensive items such as a TV and a laptop were left undisturbed in this house. Isn't that right?
That's true, because I don't think a robbery was committed at the home. I think a murder was.
But you do say that a burglary was intended.
Intended, however, not executed.
However, because nothing of value in this house was neither stolen nor even disturbed, there's very little evidence from the crime scene that this was intended to be burglary. Isn't that right?
That is correct based off the house. However, there are screenshots saying that it was intended to be a vandalism.
And speaking of those screenshots, I understand that you spoke with Alex Fuentes about them, but you never received the physical proof of this communication, did you?
Of physical proof of the text?
Yes, you never saw these text messages on Alex Fuentes' phone.
No, I did not, but I received screenshots of the text with Avery Becker.
But screenshots can be faked.
They could, but I don't think any of us think that Alex Fuentes committed this murder. So therefore, Mr. Fuentes has no reason to alter the screenshots.
And you still accepted these screenshots, though, even though Mr. Cifuentes offered to come back to the station with his phone?
Well, I didn't find need for that. The screenshots sufficed.
Even though Alex Cifuentes is technically a suspect in this case?
Yes. However, I'm pretty sure the screenshots are accurate. I'm sure of that to a reasonable doubt.
But you can't be 100% sure that these text messages were ever sent, can you?
That's true.
And you never spoke with the alleged sender of these text messages, Avery Becker, did you?
I tried to. However, the attorney canceled that interview.
Right. Let's talk about cell towers for a moment. Isn't it true that if the cell tower is particularly busy, it can connect with a tower up to 7 miles away?
Yes. However, I've learned that it's very hard for a cell tower to get so busy that it would need to connect the phone to another tower.
But the cell towers surrounding Mr. Brackman's house also connected to busy areas like the mall.
No, there's a tower that is located right by Mr. Brackman's house, and then there's another tower located right by the mall.
Right, but since cell towers can connect up to 7 miles away, it's possible that both of these towers were covering the mall.
Possible, however, not likely.
Regardless of that, cell tower data really can't give you the precise location of a person, can it?
It can give me a pretty good location of where the phone was at.
And you're aware that Avery Becker lost his phone on March 5th, 2020?
I have heard that.
So even if you did know the precise location of Avery Becker's phone, that doesn't necessarily give you the precise location of Avery Becker's person, does it?
Well, no, I don't think cell phone tower records will tell me where a person is at. Don't think that's how they
You're
work.
trying to give the location of Avery Becker by having the location of his cell phone, aren't you?
Well, I believe that the defendant is a teenager, and I'm sure that he had his phone with him.
Even though he claimed that he lost it the day before?
He claimed that.
You knew that he claimed to be looking for his phone on the day of Mr. Brackman's death.
Correct.
But you never spoke with Taylor Perkins, who could have confirmed this alibi, did you?
No.
And you had the call history of Mr. Becker's phone, is that right?
Correct.
And this showed repeated calls from Taylor Perkins that were never picked up.
Yes, that is correct, but that could be because the defendant was busy committing a murder and breaking into a house and murdering their mock trial coach at the time that his friend was calling him.
You also just said that the defendant is a teenager. It could be that they were looking for their phone and never picked up because they lost it.
Or it could mean that they were busy committing a murder when their
Regardless
friend was
of this,
calling.
You didn't consider that Becker might not be answering because he was not currently in possession of his phone.
Regardless of the murder, I believe that we're all
No.
here because of the murder.
Detective, you realize that the only suspect that you have in this case is a young high schooler with no other motive for murder than getting kicked off the mock trial team?
Yes.
And you didn't look into any other more likely suspects than this.
No, because I had already found out who committed the murder.
And this young high schooler might not have been anywhere near Mr. Brackman's house on the day of the murder.
Or he could have been murdering his mock trial coach.
But it's possible that this young high schooler, with, again, no other motive for murder than getting kicked off the mock trial team, was not in possession of their phone and therefore was not anywhere near Mr. Brackman's house on the day of the murder.
Or it is possible that he had his phone, his best friend tried to call him. He did not pick up the calls because he was busy breaking into his mock trial coach's house and then stabbing the coach in the back, leaving the coach to die in a pool of his own blood.
Thank you, Detective Markowitz. No further questions, Your Honor.
Redirect.
No, Your Honor.
Thank you. Detective Markowitz, you're excused. Next witness.
Thank you, Your Honor.
Next witness for the people.
Your Honor, we would like to call Alex Fuentes to the stand.
Mr. Fuentes, you've already been sworn. You can proceed, Mr. Phelps.
Thank you. Good evening, Mr. Cifuentes. My name is Aiden Phelps, and I'm here to ask you a few questions. Now, Mr. Cifuentes, can you please state your full name and spell your last name for the record?
Yes, my name is Alex Cifuentes. Last name spelled Sifuentes.
Mr. Cifuentes, do you know Avery Becker?
Yes, I do.
How did you know him?
Avery is a good friend of mine on our mock trial team, or was on the mock trial team.
How do you describe Avery Becker?
Avery is a very impulsive person.
And did this reflect about how he did mock trial?
Yes, very much.
Yeah, so, did Avery know Coach Brackman?
Yes, Avery did know Coach Brackman.
How was the relationship?
It was not a good relationship. It was very argumentative.
And were you there the Tuesday night after regionals?
Yes, I was.
Did anything happen?
Yes.
What?
Well, we were going over our...
Objection, Your Honor, vague question.
Oh, this is not a big question. I was asking about the events of what happened during the night after regionals?
Response? Reply,
Um,
pardon.
I'm simply asking that you restate your question so it provides more context.
Okay,
Well,
I can restate it.
Hey, I have a job to do here. I'm going to sustain the objection on the not so much on the idea that it was vague, but on the question, it called for a narrative. I will sustain the objection for that basis. But as Ms. Kiefer said, that can be cured if you ask more specific directed questions, please, Mr. Phelps. Next question.
Okay, thank you, Your Honor. So, did Coach Brackman and Avery, did they have any sort of altercation?
Yes.
Okay. And can you please describe this a bit more?
Yes. Coach Brackman was yelling at Avery about Avery's lack of preparation and how Avery brought the team down because of this at the competition.
And after this, what did Avery do?
Avery stormed out of practice in anger.
Do you know of anything about what happened after he stormed out of the room?
Yes, I do.
Can you please tell me what happened?
Yes, Avery went out to the parking lot and vandalized Coach's beloved white Porsche with permanent marker.
Did Avery appear to have any sincerity or feel bad about it at all?
Can you please restate the question?
Did Avery appear to feel any remorse for Coach Brackman about what he did to his car?
No.
And what did Coach Brackman do about this?
Coach Brackman saw what Avery did to the car and kicked Avery off of the team.
And did you have any other interactions with the defendant after this incident?
Yes, I had talked to Avery in person and received a text message from her.
Your Honor, I am constructively showing the opposing counsel what has been previously marked as Exhibit 14 for identification.
All right.
Permission to constructively approach the witness.
You may do so. Thank you.
And may my technician please display Exhibit 14.
Certainly. You can proceed.
Thank you. Mr. Cifuentes, do you recognize this document in front of you?
Yes, I do.
What is it?
It is a text conversation that I had with Avery Becker.
And are these messages accurate?
Yes.
Complete?
Yes, they are.
And truthful?
Yes.
Your Honor, at this time, the prosecution moves to enter Exhibit 14 into evidence. Its authenticity has been stipulated to and its accuracy shown.
Any objection to 14, although isn't 14 already in evidence, Counselor?
Oh, I thought it got
No objection.
objected to.
Pardon me?
No.
No, you're not objecting anyway, right, Ms. Kiefer?
Nope.
14's admitted, but just a footnote, folks. I already admitted 14 during Markowitz's testimony, so 14's already in evidence. You can proceed, Counsel.
Thank you. Okay. So in the top part of the text messages, Avery Becker was trying to get himself back on the team and requesting for you to talk to Coach Brackman. Did you give in to his pleas at all?
Not at first, no.
But eventually you did?
Yes.
And did Coach Brackman, what did he say?
Coach Brackman was not going to hear any of it. He did not want Avery back on the team no matter what.
And in the bottom portion, he says, well, if he's still upset about his car, then what is he going to, he's going to be real upset when he sees what I do to his house. I'm going to wait until he's at work, then break in and trash it. And did you take this seriously at all when he said this?
At first, yes.
And if you thought he was serious about it, why did you not alert anyone that he was going to break into his house and trash it?
Well, at first I was alerted by it, but later that evening when I spoke with Avery at the Fry Shack, Avery had seemed calmed down and I felt that Avery no longer was going to do this.
Okay. Thank you. We don't need that exhibit anymore. So after the next interaction you had with the defendant was at the fry shack, you said?
Yes.
And what did you do with the defendant at the fry shack?
We talked about how Avery had been kicked off the team, and I told her that Coach Brackman would not let Avery back on the team, and Avery even let me play a game on her phone.
And after you played the game on his phone, did you do anything else?
Well, after I played the game on the phone, Avery and Taylor left the fry shack.
Thank you. So based on your relationship with the defendant and what you noticed about how he was acting after he got kicked off the team regarding the text messages and defacing his Porsche, do you think he is capable of committing violence?
Yes.
Objection, speculation.
This is not speculation because this is not about the ultimate question.
I'm gonna any reply, Ms. Kiefer?
No, Your Honor.
I'm gonna overrule the objection. You can answer.
Thank you, Your Honor. And Mr. Cifuentes, I know this may be very difficult for you testifying against a really good friend of yours, but what brought you here in this courtroom to testify against him now?
Well, I believe in people knowing the whole truth of the matter. And as I believe that Avery did kill Coach Brackman, I feel that the court and everybody should know the truth about the matter.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. So you liked your coach, right, Mr. Cifuentes?
Yes, very much.
And you thought he was a really good lawyer, right?
Yes, he was one of the best.
And you said that he was frustrated with Avery quite often, right?
Yes, he was.
And it's fair to say that you believe that you put in a great deal more work than Mr. Becker, right?
Yes, I believe that is fair to say. I worked much harder than Avery.
And would it be fair to say that you and Avery are perceived as rivals?
In a sense, yes. We are friends, but we do compete against each other to get the top spot.
But you would get frustrated with Avery's lack of work ethic, right?
Yes, I believe that as Avery didn't prepare well, Avery brought down the team because of this, as we didn't know what Avery would come up with in competition.
Okay, let's change topics. You saw Avery on March 5th, right?
Yes.
And he gave you his phone to play games on, right?
Yes.
Did you give Avery his phone back?
That is not my statement. Would you like me to answer that?
No, thank you. Did you know that Avery lost his phone on March 6th?
No, I was unaware.
Are you aware of who Blair Rollins is?
Yes, I have seen Blair around.
And are you aware that Mr. Brackman contributed to putting Blair Rollins' dad behind bars?
Yes.
Okay. Moving on, you say that Avery texted you threatening to trash Brackman's house, right?
Yes.
And you claim to have given these screenshots to the police that say that Mr. Becker planned on breaking into Mr. Brackman's house, right?
Yes, I did give the screenshots to Detective Markowitz.
And you didn't tell anyone that Avery was planning on breaking into the house, right?
No, as I had said earlier, after I talked with Avery at the fry shack, Avery had seemed cooled down. But once I learned of Coach Brackman's death, I was very concerned.
And you didn't give your phone to the police because you had left it at home, right?
Yes, my phone was getting very old, and as I was in a rush out of the house, as it was charging, I forgot to grab my phone.
And the police didn't need your phone, right?
Detective Markowitz asked for my phone in the first interview, and I said I did not have it, but I would be willing to come back for another interview. And she told me that screenshots would be fine.
And you are no longer in possession of the phone with these text messages on it, right?
No, I'm not.
So just to confirm, the only source of these pictures is you?
Yes.
Okay. Thank you, Your Honor. No further questions.
Thank you. Redirect.
No, Your Honor.
Thank you. You can step down, Mr. Fuentes. Next witness for the people.
Your Honor, the prosecution calls for Kyle Kuzak.
Mr. Cusack, you've already been sworn. You can proceed, Counselor.
Thank you. All right, Mr. Kuzak, I would like to ask you a few questions today. Are you all right with that?
Yes.
All right. Could you please state your full name and spell the last name for the record, please?
Kyle Kuzak, Kuzak.
All right. Are you currently employed?
Yes.
What is your current employment?
I am currently a crime scene reconstruction investigator at the Denver Police Department.
What does a crime scene reconstructor do?
A crime scene reconstructor assists detectives in analyzing evidence and rendering an opinion on how a crime occurred.
How are you qualified to do that?
I am a certified crime scene reconstruction investigator and have lots of experience over the past 19 years.
How long have you been doing this? Oh,
I've
wait.
I've been a reconstruction investigator for 19 years, with the last 3 at the Denver Police Department.
What training do you acquire? What training do you undergo to acquire this job?
I received training during my certification and have lots of experience on the job.
What type of crimes do you work with in your job?
I work with various violent crimes along with various property crimes.
All right. Your Honor, at this time, the prosecution moves to enter Kyle Kuzak as an expert witness under the rules of 702 in the field of crime scene reconstruction, as he has showed the correct skills, knowledge, education, experience, and training needed to be qualified in this field.
Any objection to Mr. Cusack being accepted as an expert witness?
No, Your Honor.
Mr. Cusack will be accepted as an expert witness and permitted to give opinions in the fields in which he was tendered. You can proceed, Mr. Wolpert.
Thank you. All right. What is your relationship to this case, Mr. Cusack?
I was assigned to reconstruct the crime that occurred in this case.
What does an assignment to this case entail?
An assignment entails reviewing all the physical evidence, the police reports, photographs, and visiting the crime scene.
What would a crime scene reconstruction tell us about the crime?
A crime scene reconstruction would tell us how the crime occurred. This can be critical to parts of the investigation, to who committed the crime, and it can help the jury visualize what happened.
How do you form your opinion?
I form my opinion by following my key principles, assuming that every case is going to trial, and I also make sure all the evidence I have is memorized, documented, and organized.
Is there a methodology to this?
Yes, I approach my work in 5 parts. These parts are recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction.
So what happens in step 1 of your process?
In my first step, I create a witness tracking spreadsheet, an evidence tracking spreadsheet, and a basic flow chart to show chronological relationships between evidence.
What would that include for this crime?
For this crime, the witness tracking spreadsheet would include various students of Colorado High School mock trial team, the victim's neighbor who discovered Mr. Rackman dead, the responding EMT, and the evidence technician.
What happens in step 2 of your process?
In step 2 of my process, I expand the existing organizational framework for information. This is pretty much just expanding on the evidence tracking spreadsheet and preparing it for analysis.
Now, step 3?
Step 3 is pretty much just more of what happens in step 2.
And then step 4?
And step 4 is to formally conduct my analysis and develop my hypothesis based on the evidence. I apply the Bevel and Gardner 7-step methodology for event analysis.
All right. In step 5, Mr. Kuzak?
In step 5, I draft my initial report, get the initial report peer reviewed, and then create my final report.
So through these 5 steps, what did you conclude about this case?
I concluded that the case was a premeditated home invasion gone wrong.
Have you reviewed the ring footage for this case, Mr. Cusack?
Yes.
Your Honor, may I show the witness exhibits 10, 12, and 13 for identification?
You may do so.
All right. Can co-counsel please pull that up?
How are we doing on that? Are we getting it up?
I still do not see it.
Your Honor and counsel, if it's easier, I could pull it up on my own.
Why don't you go ahead and do that?
Okay. Okay, I believe I have it now.
All right.
Go ahead.
Thank you. Do you recognize this image
Yes, I do.
or these videos? Sorry.
Yes.
How do you know these videos were taken at the scene of the crime?
The videos were collected by Detective Markowitz from the account of Mr. Brackman.
All right. Your Honor, the prosecution moves for submission of exhibits 10, 12, and 13 as their into evidence as their accuracy has been shown and authenticity stipulated.
Any objection to what numbers again? 10, 12, and 13, Mr. Walper?
Yeah.
Thank you.
Yes, Your Honor.
My own handwriting. Any objection to exhibits 10, 12, and 13?
No, Your Honor.
Exhibits 10, 12, and 13 are admitted. Next question, Mr. Walpert.
Thank you. What do these ring videos show, Mr. Cusack?
The ring videos show the perpetrator approaching the home. The perpetrator is about the same size and build as the defendant today. They approach the home. They check to see if they can enter the front door, but they cannot. The perpetrator then goes to the backyard and approaches the back sliding door, opens the door, and enters the residence.
All right. Let's move on to the murder weapon. Your Honor, may I show the witness exhibit 5 for identification?
You may do so.
Do you have this pulled up, Mr. Cusack?
Yes,
All right. Do you recognize this image?
I do.
How do you know this image was also taken at the victim's residence?
This image was taken by the forensic team at the residence and was submitted into evidence and properly handled.
All right. Your Honor, the prosecution at this time also moves to enter exhibit 5 into evidence as its accuracy has been shown and authenticity stipulated.
Any objection to 5?
No, Your Honor.
5's admitted.
Thank you. What was the murder weapon in this crime, Mr. Cusack?
The murder weapon of this crime was a Chicago cutlery chef's knife. It was found aside the victim's body by the front door.
Where did this murder weapon come from?
From my professional and expert analysis of the case, I can confidently assume that the murder weapon came from the knife block in the victim's kitchen. The knife block was missing the appropriately sized chef's knife. However, they are different brands. It would be very reasonable to assume that if the original knife was lost or damaged and it was replaced by this one.
Thank you. Now let's finally move on to the scuff marks. Your Honor, may I show the witness exhibit 18 for identification?
You may do so.
Right. Do you see the image in front of you, Mr. Cusack?
Yes,
All right. Do you recognize this image?
I do.
How do you know this image was also taken at the victim's residence?
This photo was also taken by the forensic team who arrived at the scene, and the evidence was properly handled as shown in the stipulated facts.
All right. Your Honor, the prosecution also moves for submission of exhibit 18 into evidence as its accuracy has been shown and authenticity stipulated.
Any objection to 18?
No, Your Honor.
18's admitted. Next question, counsel.
Thank you. Mr. Cusack, can you tell us about the scuff marks found at the victim's residence?
The scuff marks at the victim's residence are another pointing factor to the fact that a struggle occurred between Mr. Brackman and the perpetrator. These scuff marks were pretty much right inside from the back door of the residence, which is consistent with the fact that the intruder entered through the back door.
All right. What other evidence points towards a struggle?
In addition to the scuff marks, a broken plate was at the scene of the crime in the kitchen table, which is about 5 feet from the back door.
What about the fingerprints and DNA you gathered in this case?
All the DNA, fingerprints, blood found at the scene was the victim's. This is consistent with the fact that the perpetrator was wearing gloves.
All right, thank you. Have you heard the defense's conclusion of this case, Mr. Cusack?
Yes.
What do you think of Mr. Van Owen's theory?
Frankly, I think that Mr. Van Owen's theory is stupid and unsupported by evidence.
Why did you come to that opinion?
Mr. Van Owen's theory is that Mr. Brackman was stabbed in the back while he was sitting at the table with a knife that the perpetrator brought with him. This theory is not supported by the physical evidence found at the scene of the crime, which, by the way, he did not visit. All that Mr. Van Owens did was read my report and look at other ways to interpret evidence that supported his conclusion that he had created before even looking at any evidence.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Cusack. Today I'll be asking you some questions regarding your involvement in this case. Were you able to examine all evidence relating to this case?
I was able to examine all the evidence that was collected for this case, yes.
Are you aware that certain photographs of evidence, such as photographs of blood cast off, were lost?
Yes.
Are you also aware that digital files of the photographs from the crime scene became partially corrupted?
Yes, I believe those were the ones that were lost.
Isn't it true that in your statement you said you were not able to recreate all event segments or place all evidence?
Yes.
Do you think you would need more evidence to come to a conclusion?
No.
But you said you would prefer that you had more physical evidence, right?
I prefer, but like I said in my statement, some of the missing physical evidence is consistent with my theory of, for example, how the stabbing occurred.
Let's move on. Do you know Blake Van Owen?
Yes.
Isn't it true that some of Blake Van Owen's conclusions fall outside your area of expertise?
Yes. However, his theory on how the crime occurred is in my expertise, and that is what I testified to today.
Is there any bad blood between you and Van Owen?
I've known him from conferences. I wouldn't say there's any bad blood.
Thank you, Mr. Cusack. That is all, Your Honor.
Redirect.
No redirect, Your Honor. Thank you.
Thank you. You can step down. The witness can step down. Any additional witnesses or exhibits for the people?
No, Your Honor.
People rest.
Yes. Yes, Your Honor.
People have rested. Anybody besides the judge who needs what the English refer to as a comfort break?
No, Your Honor.
Yeah, well, you're all younger than I am. I am going to step away for less than 5 minutes. I will be back. If anyone else needs to make a short trip, please do so. By my clock, it's 2:52. I will be back no later than 2:57. Thank you. don't know if anybody else decided they needed to go, but I'm back. I don't see that anybody else has departed. All right. Defendant ready to proceed?
Yes, Your Honor. The
First-
defendant, oh, sorry.
Pardon me, Ms. Burnham?
The defense would like to call Professor Blake Van Owen to the stand.
Professor Van Owen? Remember, all the witnesses have previously been sworn. You can proceed, Ms. Burnham.
Thank you, Your Honor. Good afternoon, Ms. Van Owen. Please state your name and spell your last for the record.
Good afternoon. My name is Blake Van Owen, O-W-E-N.
Why don't you start by giving us a little bit of information about yourself? What's your current profession?
Well, I'm a private investigator and a professor at CU Denver. And while working there, I taught a few courses on police practices and social justice. I am also an expert witness in police practices. Also, because of the hard work that I put in to get my master's degree, I prefer to be called Professor Van Owen.
And where did you receive this master's, Professor?
I obtained my master's degree in criminal justice through the Ashford University online program.
Do you have any specialties in private investigation?
Well, I regularly act as an expert courtroom witness in the areas of police practice, use of force, false arrest, and forensic evidence techniques. I also testify as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics. I was also formerly a police officer for the Aurora Police Department.
And what's your experience giving expert witness testimony?
Well, I have been accepted as a defense expert in Colorado, Kansas, Arizona, Wyoming, Nebraska, and New Mexico. I have been in various courts as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. And I have consulted on more than 100 cases.
Your Honor, based on the witness's education and experience in the fields of forensic evidence techniques, crime scene reconstruction, cell tower analysis, and general police investigation tactics, the defense moves to enter Professor Blake Van Owen as an expert witness in all these areas pursuant to Rule 702.
Any objection or voir dire?
We would like to voir dire, please.
All right. Remember that in real life, voir dire goes only to qualifications, not to weight, but you can proceed.
Yes, Your Honor. So, Professor Blake Van Owens, you have practiced as an expert in courtrooms for police practices, use of force, false arrest, and forensic evidence techniques, correct?
Correct.
And do you have education in each of these?
Yes.
And you have also testified in crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Yes, multiple times.
Do you have any education for cell tower analysis?
Yes, not stated in my statement.
That is it for voir dire, Your Honor.
Any objection to Dr. Van Owen being accepted as an expert?
Just for cell tower analysis, Your Honor, because it wasn't mentioned in their witness statement at all. They had any education on it at all.
Response, Ms. Burnham?
Based on the witness's extensive experience in cell tower analysis, we still move for the admission as an expert.
Any objection, any reply to that, Mr. Phelps?
Well, just because they have experience for testifying as an expert in that area doesn't mean that they have an education for it. And just because it's happened before doesn't mean that they're necessarily still qualified for it.
The objection's overruled. Dr. Van Owen will be accepted as an expert in the field in which he was tendered and permitted to give opinions. You can proceed.
Thank you, Your Honor.
May I proceed, Your Honor?
Yes.
What's your involvement in this case today, Professor?
While I reviewed the state's crime scene and cell tower reports regarding Mackenzie Brackman's death, as well as conducting my own partial investigation of this case.
And what did you review first?
Well, first I looked at the investigation of Jordan Markowitz, particularly regarding the cell tower records he acquired.
What did these records show?
These records show repeated calls from Taylor Perkins to Avery Becker's phone, almost like it was lost and Perkins was trying to find Becker's phone. Teenagers often lose their phones. These also show the relative location of Becker's phone.
And where did Avery's phone appear to be on March 6th, 2020?
Well, Avery's phone was shown to be at about the area of his house, the mall, the fry shack, and yes, Mr. Brackman's house, at about the time of Mr. Brackman's death.
So can this data show an exact location for Avery Becker?
Not precisely. Cell tower data is not remotely like a GPS in terms of precision. A phone may connect with the tower up to 7 miles away, which means that Becker's phone may not have even been close to Brackman's house at the time of the murder.
Was there anything else that you were able to learn from the cell tower data?
Well, unfortunately, because only a very short window of time was investigated, there's very little else I could gain from these records. If Markowitz had gotten a wider window of data, for example, all the phones that connected in the area, or multiple days worth of data, it may have been a bit more helpful.
Were there any other shortcomings in Detective Markowitz's investigation?
Well, Detective Markowitz simply accepted screenshots of text messages from Alex DeFuentes to use as evidence against Avery Becker, rather than actually obtaining his phone records and verifying the evidence. And as you heard earlier today, screenshots can be easily photoshopped or faked.
And based on your knowledge of police practices, could Markowitz have obtained the record of these text messages?
Yes, he could have easily done this. The Aurora Police Department uses a technology called Celebrite, which allows them to download contents off of any phone. It is beyond me as to why they would not use this technology in a murder investigation.
Is there anything else that you reviewed in this case, Professor Van Owen?
Yes. Next, I reviewed the work of Kyle Kuzak, where I found significant issues regarding the nature of the stabbing.
And what issues were these?
Well, first, there is knife work supported by Kuzak. He thinks that the intruder wrestled control of the knife from Brackman, and then proceeded to stab him in a bear-like position.
Is there anything wrong with this theory?
Well, first, the murder weapon is not the same brand or dimension as any of the knives in the house, so it doesn't make sense that Brackman would have this knife. And second, the construction of the knife handle is conducive of stabbing in the back, not the strange bear hold. This is one of the things that made me unsure of the theory that there was some struggle.
Was there anything else that negates the fact that there was a struggle?
Yes, Kuzak says that certain scuff marks near the back door point to a struggle, but we have no idea how old those marks are. Also, although the victim was in possession of a Ring doorbell, which may have notified him of an intruder, we have no way of knowing whether notifications were turned on, because there was no follow-up on the user account records.
You mentioned Ring videos. Was there anything else that you learned from these?
Well, I learned that the intruder was not big enough to have bear-hugged Brackman. I also learned that the intruder was the same size and build as another suspect in this case, Blair Rollins.
Do you know who Blair Rollins is?
I gained knowledge of Blair during my investigation of this case.
And who is Blair Rollins?
Well, Rollins is an alum of Colorado High School, where Mr. Brackman was a mock trial coach. Moreover, their dad was a client of Mr. Brackman's, who was sent to prison for life. There's actually an audio recording of him threatening Brackman after the hearing.
Do you know what this recording says?
It said something of the sort, "I'll get you back, Brackman, if it's the last thing I do."
Was Blair Rollins present when this recording was taken?
Yes, she was. She had testified for her dad during the hearing. She would have known about this threat.
And in your expert opinion, Professor, is it possible that Blair carried out this threat for her father?
Absolutely. It is a far stronger motive for murder than simply being kicked off the mock trial team. Moreover, Rollins was absent from school on the day of the murder, leaving them with no alibi.
And where is Rollins now?
Rollins is effectively missing in action. I tried to get a hold of them during my investigation, but it seems they've just disappeared after graduation. My guess is that they're no longer in state.
Thank you, Professor Van Owen. No further questions, Your Honor.
Cross-examination.
Yes, please.
You can proceed.
Good afternoon, Professor Van Owen. My name is Aiden Phillips. I'm here to ask you a few questions. So, Professor Van Owens, earlier you said that, did you say that it was possible that, you mentioned that teenagers lose their phones a lot. Were you referring to what could have happened to the defendant?
Yes.
But in your witness statement, did you not say directly, without a maybe, that you know that his phone was stolen?
I never stated that his phone was stolen.
But didn't you say this in your witness statement?
I don't believe so.
Okay. But do you think it is possible?
It's possible his phone was stolen. I don't think it is very likely.
All right. Well, moving forward, let's talk about your theory about Cifuentes and why you do think that the messages were faked. So do you think that the messages between Alex Fuentes and Avery Becker were doctored?
Can you repeat the question?
You think that the text messages between Alex Fuentes and Avery Becker are doctored, correct?
I think it is a likely possibility.
And is there anything specifically about the text messages that would show this?
There's nothing specific in these text messages that would show this, but it is text messages such as these are very easily photoshopped or faked. So I'm not saying that these text messages would have been faked, but I'm saying that the Detective Kuzak or Markowitz simply accepted these screenshots instead of actually receiving hard evidence.
But do you think they are fake?
Yes.
All right. Now let's talk about your theory about how the murder actually happens. You disagree with Kyle Kuzak, correct?
Yes, I do.
And you think that he was snuck behind and stabbed, correct?
Correct, yes.
And you don't think that there was any sort of fight that happened between them, and he just did not even know he was there at all?
No. If Mr. Brackman would have heard an intruder, he would have put up a fight. But I'm not saying that the scuff marks found near the back door point to a struggle.
Do you think that, but you are aware that there were broken plates on the floor, correct?
Yes, and he could have easily dropped that plate and meant to clean it up later.
You think that people just drop plates on the floor and don't immediately pick them up?
I do it sometimes, so yes.
Okay, thank you. And as well, you are aware that there were recordings from the Ring Video Doorbell app, which can have push notifications on people's phones, correct?
That is true, but we do not know whether those notifications were turned on or not.
And do you think that the killer held the knife in the upright position?
Yes, that is possible.
But you are aware that the autopsy report and Kyle Kuzak's recordings showed that he had a deep stab that went downward, well, slightly downward. So how would that occur? Does that make any sense at all?
Can you rephrase the question?
So you said that the knife was stabbed upward, right? That it wasn't held in a downward position.
Yes.
But you are aware that the autopsy report suggested completely otherwise, that it had a slightly deep angle.
Yes.
Yet you still stand by your theory that he was snuck up from behind, correct?
Yes, even when cutting food, that can happen. A deep cut and not holding it in such a position that Cusack supports.
Slightly downward cut, even if you're holding the knife upward.
Objection, Your Honor. Asked and answered.
Response?
I'm simply clarifying. I just am wanting clarification for what she said.
Reply.
The witness has already answered that she believes that it was an upward cut, not a downward cut.
Several times. The objection sustained. Next question.
And you were paid $225 an hour per hour for this research, right?
Correct.
And 450 hours to testify, correct?
Correct.
And did you say in your report, I have been asked to offer the following opinions?
Can you repeat the question?
Did you say in your witness report, I have been asked to offer the following opinions?
Objection, Your Honor. Relevance.
This shows bias.
Any reply, Ms. Brennan?
I fail to see how what the witness was asked, I fail to see that the fact that the witness was asked to provide opinions on this case goes to what actually happened.
Well, this is just for bias.
I'm going to overrule the objection. Let's see if we can tie this up, Counselor.
Thank you, Your Honor. No further questions.
Okay. Cross-examination.
May I have a redirect, Your Honor?
I'm sorry. Do you want? It'd be nice if I could read my own notes. My apologies, Ms. Brennan.
No worries.
Redirect examination is appropriate. Thank you.
Professor Van Owen, would you ever let any personal bias get in the way of your work?
No, and in terms of money, as Mr. Phelps was stated earlier, that is my hourly rate. I would be earning the same amount as any other case, and this case. I would be earning the same amount. I am no bias.
Thank you, Professor. No further questions, Your Honor.
Thank you. Witness can step down. Next witness for the defendant.
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Ms. Perkins, you've already been sworn. You can proceed.
Good afternoon, Ms. Perkins. Please state your name and spell your last for the record.
Taylor Perkins, Perkins.
And do you know Avery Becker?
I sure do.
How do you know Avery Becker?
Avery Becker is my best friend. We attended the same high school together and we were both on the same mock trial team.
Were you on the same mock trial team for your entire high school career?
Not throughout it all, no. Our senior year to last year, once Avery was demoted down to B team, I had stepped down so Avery could regain her spot back on A team.
And why did Avery get demoted to B team?
Our coach, Mr. Brackman, he and Avery often did not get along. They were often in a feud with each other. So about a month before regionals, Avery came to practice much more unprepared than normal. And so they fought and Mr. Brackman demoted them down to B team.
Who is Mackenzie Brackman?
Mackenzie Brackman was our coach.
And how was Avery's relationship with Mr. Brackman?
They both didn't quite see eye to eye. They were often got heated with each other. Mr. Brackman liked to have us be very prepared and in our practices, but Avery did a really good job at improvising and making things up the fly. So he didn't really like to prepare all too much.
Did something happen at the regional tournament?
At the regionals tournament itself, it was fine. However, afterwards, Avery had gotten 2 awards, one being the best attorney award, and then also best closing argument. But Mr. Brackman didn't quite think Avery deserved it. I wasn't there at the practice, but I heard about it from Avery. Apparently, they fought over it, and there was some pretty rude words exchanged, to my understanding. And Avery had angrily grabbed what we had thought was a dry erase marker. We later found out it was a permanent marker and wrote "Worst Attorney Award" on Mr. Brackman's car.
How would you describe Avery?
Avery is a good friend of mine and a loyal friend too. However, they are impulsive.
Do you know Alex Cifuentes?
I do.
And what was Avery's relationship with Alex?
They honestly didn't seem to like each other too much. Alex claims that they were friends. However, they always seem to be extremely irritated with each other.
Did you know that Avery lost his phone?
Yes, we didn't realize until the morning of March 6th.
And where did you go when you realized Avery's phone was gone?
The night prior, we had gone to Fry Shack, which we also saw the rest of the mock trial team. And then we also had gone to the mall. The next morning when Avery came to pick me up, I had called and texted him multiple times and he never responded. That's when we realized that he had missed his phone. So that day we had spent the day searching for his phone. Going back.
Objection, Your Honor.
The objection.
Narrative. I move that the witness's answer be striked.
That would be stricken, Counselor.
Stricken.
Of course they have. That's okay. Any response to the objection, the narrative objection?
I'll break it up.
So the answer is you're withdrawing your previous question and going to.
Yes, Your Honor.
The objection sustained. Next, you can proceed.
What did you do on the morning that Brackman died?
That morning, Avery had picked me up from so we can go to school together. And once we realized Avery's phone was missing, we went to go look for it.
And where did you go look for it?
We retraced her steps from the night before. We had gone to the Fry Shack and to the mall in hopes of finding it.
Let's move on. Have you heard of the supposed text exchange between Alex and Avery?
Yes, I have.
And what do you think of this exchange?
They seem totally fake. I know that they did text at some point, or at least I don't know that. I thought maybe they would have, but those don't seem like something Avery would have said to Alex at all.
Do you know who Blair Rollins is?
I do.
And who is Blair Rollins?
Blair Rollins was a student who attended the same high school as Avery and I and the rest of the mock trial team. Blair Rollins was a little strange. He had a loose wing, I would say, but we all knew that his father did not get along with Coach Brackman.
Thank you. No further questions, Your Honor.
Cross. I'm sorry, cross-examination.
Yes, Your Honor. Hello, Ms. Perkins. My name is Calvin Patel, and I will be cross-examining you today. Let's start with your relationship to Avery Becker. You and Avery are best friends, right?
I say so, yes.
Okay. And as a best friend, you'd say she's often rash?
He, and yes, I would.
He, excuse me, has an inflated ego?
Yeah.
You would say that Avery drove Brackman crazy?
I would say it was a two-way street. They both drove each other crazy, but nothing really extreme. It was a feud between the two.
Is it your testimony today that Avery did not drive Brackman crazy?
Can you define crazy for me?
No, not at the moment.
Well, then I would say, no, not really.
Okay. You previously gave a statement in this case, correct?
Correct.
And this was a sworn statement?
Yes.
And you told the truth in this statement.
Of course.
Would the technician please display the witness statement of Taylor Perkins? And could you go to the first page?
I believe the beginning of Taylor Perkins' statement is on page 40.
Do you recognize this, Ms. Perkins?
I do.
Is this your statement?
It is.
Could you go to the last page of Taylor Perkins' statement? Is this your signature, Ms. Perkins?
It is.
And are you aware that you could have changed your testimony up until this time?
I was aware, yes.
Could you please go to line 15? Would you please read this silently as I read out loud?
Of course.
Even unprepared, Avery was still better than everyone else on the team, and that drove Brackman crazy.
Yes.
Thank you. Moving on.
I would like to point out the fact that Avery was one of the best people on the team was what drove Brackman crazy. Avery himself did not drive Brackman crazy.
And being demoted from the A team upset Avery, right?
Of course it did.
Okay. So upset that and you left the scene just so that she could get back on, correct?
Of course.
And after getting back on, after a dispute, or there was a dispute after getting back on, correct?
There was.
And after this dispute, Avery decided to write worst attorney award on Coach Brackman's car, correct?
They did do that, yes.
And this ruined the paint on the car?
Objection, relevance.
What's the relevance, Counselor?
It goes to the state of mind of Avery Becker and shows, it shows her state of mind.
Response? To reply, pardon me.
I do not see how this would show the state of mind of Avery Becker.
Is it done that? The objection's overruled. You can proceed. You can answer the question, please.
Thank you, Your Honor.
Do you mind repeating the question for me?
Of course, Ms. Perkins. This ruined the paint on the car, correct?
It did so, yes, but that was not Avery's intention.
Okay. And this was because she was kicked off of the team.
Out of anger and spite, yes, Avery did write that on the car. But what we have both thought was a dry erase marker.
Okay. And Avery tried to get back on the team after, but Brackman wasn't having any of it, was he?
To my knowledge, yes.
Avery even showed up to practice on March 5th, but was asked to leave?
I believe so, yes.
And this was the night before Brackman was murdered?
Yes.
Okay. That night you and Avery went to the Fry Shack, right?
We did.
And a few people from the team showed up?
Yes.
Then Avery got really upset and stormed off to the bathroom.
That is correct.
And you think that the phone was still on the table when they left, but you were not sure, are you?
I am not 100% sure, no.
And on March 6th, the two of you realized that Avery's phone was missing.
Yes.
And the two of you went to go look for this phone?
We did.
And skipped school that day to do it?
Yes. All of our classes were dry. There was no need to go.
And searched everywhere you went, including the mall?
Including the mall.
And the Fry Shack you were at the night before?
Yes, we did.
And you saw the mock trial team there, didn't you?
We did.
And was that unusual?
It was unusual because at the time we saw them, they were supposed to be in practice. Yeah.
And now you think it's creepy to know that he was dead the whole time?
Yeah, Yeah, I think anyone would consider it creepy.
But you never found Avery Becker's phone, did you?
We were never able to find it. No,
But that thing was like a third kidney to Avery.
I would like. You really only need one kidney to live. So
Um,
it was like a third kidney. However, Avery did not have to have it. You could go with only one kidney even.
okay, thank you. But neither of you remembered to locate the phone, did you?
Neither of us did. Right.
You mentioned a couple of other names in direct examination. You mentioned Alex Cifuentes.
Yes.
You thought that Alex took Avery's phone.
I thought that was a strong possibility. Yes.
And you and Alex don't get along, do you?
I would say we don't. Not really.
You thought Alex was insincere.
Yes.
You thought that Alex was trying to get your best friend Avery's roles.
Of course. Alex displayed their jealousy many times.
You thought Alex was a total kiss-up.
Most definitely.
And you wanted to punch him in the face, didn't you?
Of course, they were being completely insincere.
But you never actually saw him take the phone.
No, I did not.
Okay. And you say that Alex took this phone and gave it to Blair Rollins.
I'm saying that is a strong possibility, yes.
And you say that Blair Rollins killed Mackenzie Brackman.
Again, I think it's a strong possibility. Blair has a stronger motive than my friend Avery does.
And this makes sense because Blair Rollins is friends with Alex Cifuentes?
Partially, yes. That is one of the reasons why it makes sense.
And Blair, is there another reason for why this makes sense?
Blair Rollins' father, he was one of Mr. Brackman's clients. And in that case, he ended up being guilty. And so Mr. Brackman lost the case.
Excuse me, I'm referring to why you think that Alex would have given Blair Rollins the phone.
From what I've seen, they seem like friends. And
that's the only reason that you believe that Alex would have given Blair Rollins Avery's phone, that she would have stolen Avery's phone.
Yeah, it would have been a good prank on Avery.
Okay. And Blair Rollins is the kid that everyone thinks is a little weird.
Yes.
And even you know that this theory sounds like a stretch, don't you?
A little bit, but not nearly as much as a stretch as the theory of Avery being the murderer.
But you would agree that it sounds like a stretch.
Yes.
Okay. And you didn't even think about this theory until the lawyers called you to testify here today?
Yes.
Thank you. No further questions, Your Honor.
Redirect.
No, Your Honor.
Thank you. The witness can step down. Next witness for the defendant.
The defense would like to call out Mr. Avery Becker to the stand.
Thank you. Mr. Becker, you've already been sworn.
Good afternoon, Mr. Becker. Please state your name and spell it for the record.
My name is Avery Becker, Becker.
Why are you here today, Mr. Becker?
You see, I've been falsely accused of murdering my former mock trial coach, Mackenzie, or as I called him, Mr. Brackman.
Where did you go to school last year?
I went to Colorado High School, but we all like to call it CHS.
Why did you decide to join mock trial?
You know, it was a fun way to get out of the house. I got to hang out with my best friend, Taylor Perkins, and I ended up being really good at it.
What was your relationship with Mr. Brackman?
You know, he didn't really like me, and we kind of argued here and there, and he didn't like that I was able to make up closers on the fly, but I respected him, you know, and he really got us to work, and he made us a competitive team and got us to the top. I think at some points he was a lousy lawyer, but once again, I feel terrible for everything I've done, and I never meant any harm on him.
So how good were you, in your personal opinion, at mock trial?
I was really good. I could spin a yarn, as I like to say, and I won best closer and best attorney at regionals. And, you know, it just like came naturally to me.
What was regionals like for you?
Well, like I said, I won best attorney award and best closing, but Brackman didn't think to agree.
What happened in the practice after you went to regionals?
So that Tuesday after regionals, Brackman started saying that I didn't deserve the award and I should have stuck to the script. And I was really angry. He took away my win and he thought that I should sound over rehearsed and said I even relied on my good looks to win. And yeah, I felt I was very upset in the time. So I took what I thought was a dry erase marker that we were using during practice and I wrote on his car, worst attorney award.
How did he respond after seeing this?
Well, at first he came up to me in the parking lot after practice and he began to apologize about for what he said earlier. But once he saw the car, he got furious and kicked me off the mock trial team, which is understandable. But I was just so upset. My mock trial career was over. And if it wasn't for me and a few others on the team, we wouldn't have even gone to state.
Oh, were you aware the marker was permanent, Mr. Becker?
Of course not. As I said earlier, we were using that same marker earlier that day in practice on whiteboards. I had no reason to think it was anything else.
Did you tell anyone what had happened?
Well, I told Taylor, and I had told my mom what happened. I didn't tell her about the car, but I told her that Brackman had gotten mad at me again. I was just crying the whole time and I felt awful. And she told me to go and apologize the next day, which I decided was the best choice.
What happened when you tried to go to his office?
So the next day I felt awful still. So I went to his secretary and his secretary said that he didn't want to talk to me. And I really did want to apologize in person because I still felt awful. But I realized that may not be an option to talk to him in person. So I sent him a text apologizing and I offered to try and scrub it off. And I even offered to get a summer job to pay for it.
Changing gears, what is your relationship with Alex Cifuentes?
Oh, Alex and I have never been friends. While we were on the mock trial team together, he seemed jealous of me and the absolute last person I'd ever go to help for. But he likes to think that we're like best friends or something.
Do you know who Blair Rollins is?
I mean, not much. I know that Blair and Alex were friends, and I know that Blair's dad had gone to jail because Brackman lost the case that had gotten Blair's dad into jail. But other than that, not too much.
And what does Blair look like?
Blair looks almost exactly like me. Some have said that people could mistake the two of us together because we have the same build and look identical.
What is your relationship with Taylor Perkins?
Oh, Taylor's my best friend. We did mock trial together. We would hang out. We would text each other. And she even left the mock trial team for me.
And so where were you on March 5th?
On March 5th, Taylor and I went to the Fry Shack where all the mockers like to hang out. And we just decided to play games on my phone.
And who were you with?
As I said, Taylor was there and Alex was also there for a little bit.
So where were you the next day?
Well, March 6th, I had woken up and I realized I couldn't find my phone anywhere. And so Taylor came to my house and suggested that we took the day off of school since it wasn't important and spend the day looking for it. So we went back to the mall, we went back to the Fry Shack. And when we were at the Fry Shack, we actually saw the other team members there, which was a little weird because they were supposed to be at practice during that time. So it seemed a little weird, but they said it was because of the 15-minute rule.
Where did you try and look for your phone?
Well, as I said, we went to the mall, we went to the Fry Shack. We just tried to retrace our steps everywhere. And Taylor tried calling my phone with hers, but it just went straight to voicemail and we couldn't find it anywhere.
Finally, are you aware of the text messages Alex claims to have received from you?
Not initially, but according to my lawyers, they claim to say that I wanted to go to Brackman's house to trash it, which is just ridiculous because I didn't even have my phone. And Alex is the last person I'd ever go to ask for help.
Thank you, Your Honor. No further questions at this time.
Ross?
Yes, Your Honor. May I begin?
Yes.
Thank you. All right, Mr. Becker. Would you say that you're good at mock trial?
Yes, I would.
You would say that you're the best attorney on your team?
Yeah, I would say so.
You thought that you were better than Brackman?
Occasionally, yeah.
Because Brackman was jealous of you?
I said that Alex was jealous of me. Brackman, we got into arguments and he just didn't like my work ethic. I wouldn't say he was jealous of me.
You would say that Alex and Brackman were jealous of your genius and talent, though.
I guess you could say so.
Did you ever think to help other teammates by writing written questions?
That's not in my statement. Would you like me to answer anyways?
No, it's fine. All right. Was your way better than Brackman's?
In my personal opinion, it was better, I would say, but it was just different. It just worked better for me to come up with stuff on the fly and be under pressure, but it could work for other people to do Brackman's way.
All right. Now, you're an impulsive type of person, aren't you?
No, I wouldn't say so.
Well, that would certainly contribute to your success in mock trial, right?
I wouldn't say impulsive. I would just say coming up with stuff on the fly.
Well, coming up with stuff on the fly is very impulsive. So you would agree that you are an impulsive type of person.
No, I don't think those are the same thing.
Would you agree that you're a creature of instinct then?
I don't really understand the question. Can you rephrase it?
Would you agree that you are someone that has instinct, the impulses every so often?
No, I would say in mock trial, yes, but outside of that, no.
So you're an impulsive type of person in mock trial?
Yeah, during competitions.
Mr. Becker, would you say that your impulsive nature could lead to your emotions overtaking your logical reasoning?
No, not at all.
Well, it certainly did when you vandalized Mr. Brackman's car.
I didn't vandalize it. I wrote on it. And I still feel terrible for it. I never intended any harm.
Writing on a car is vandalization. So,
not in my personal opinion.
All right. Well, your impulsive nature also overtook your emotions when you decided to not tell your mother, whom you trust with everything, your vandalization of Brackman's car.
I really did try to tell my mom. I was just crying the whole time because I felt terrible. And I told her everything, just not the car, because I was crying and so overwhelmed.
Well, this also happened when you said that you would get Brackman, or him, if it was the last thing you do.
That was before all of that mess. I never intended it to be anything harmful. I meant it in a light mock trial way because I was upset that he took away my win. I never intended it to be anything, let alone to kill him.
All right. Thank you. No further questions.
Redirect.
Yes, Your Honor. Mr. Becker, would you say that mock trial is your passion?
Yes, I love mock trial. I did it for 4 years, and that was all thanks to Mr. Brackman.
And would you like to explain more thoroughly why you said that you would get Mr. Brackman back?
Yeah, it was just because he took away my win. I was just upset. I never meant it to be anything impulsive or anything harmful or permanent, and let alone kill him. I would never do something like that. It was simply just to get him back, meaning that I would win that I could win.
Objection, Your Honor.
What's the objection?
Narrative.
Response?
I will break up the question.
All right, the objection sustained. Go ahead.
What was your intent when you said that you would get Mr. Brackman back?
There was no harmful intention. It was nothing permanent. It was simply just because he had hurt me.
Thank you, Your Honor. No further questions.
Thank you. Witness can step down. Any additional witnesses or exhibits for the people?
The defense rests, Your Honor.
Thank you. We ready to proceed to closing arguments?
Yes, Your Honor.
Defense ready with their closing argument?
Yes, Your Honor.
All right, closing argument for the people, please.
Thank you, Your Honor. May it please the court, Avery Becker was rejected from something he loved, flew into a rage, and had his revenge. Just because the revenge was more than he intended is irrelevant. The picture that Avery Becker was simply disgruntled, that he was kicked off of his mock trial team, cannot be farther from the truth. Today we have seen how the defendant, Avery Becker, went from rejection to rage to revenge. We believe beyond reasonable doubt that Avery Becker is guilty of the felony murder and burglary of a beloved high school mock trial coach. Witnesses for the prosecution and defense have described Avery Becker as becoming furious over criticism of his mock trial efforts. His anger reached its limit when he was heavily criticized for his performance after the regional round where his team won. He received multiple awards. Who did the coach think he was talking to? Avery Becker didn't. And then after the Tuesday after regionals, he vandalized his car. And then during his witness statement, he said that he felt really bad about it and thought about getting a job. But then today in this courthouse, he said he didn't even consider it vandalism, which shows truly how perplexed of a person Avery Becker is, how he's just going to take back that he was going to try to work for getting his entire Porsche cleaned. She also pretended that the relationship was very good today, completely flipping from what she represented on her witness statement. And then after this, she went home. She didn't tell her mother that she had been kicked off the team, but she did vow that she would get Mr. Brackman back if it was the last thing she did. The defendant even tried to get Alex Fuentes to help her get back on the team. Then Mr. Fuentes advised the defendant that Mr. Brackman would not let her back on the team. The defendant went into another rage. He said he's really going to be upset when he sees what I do to his house. And despite being warned by Alex Fuentes not to retaliate, the defendant showed up at Mr. Brackman's house in the afternoon of March 6, 2020. When she entered the house, the defendant was met by Mr. Brackman, who had armed himself with one of his knives inside the back door. And as we know, this led to the death of a beloved mock trial coach. In the struggle, the defendant stabbed Mr. Brackman in the left shoulder blade. The knife penetrated downwards and severed Mr. Brackman's heart. Upon removal of the knife from his back, Mr. Brackman was dead before he hit the floor. We have the burden to prove to you beyond a reasonable doubt that all of the elements necessary to constitute the crimes charged. For both murder of the first degree and burglary, we must show that the defendant perpetrated the crimes in the state of Colorado at or about the date of the place charged while acting alone or with others. And we can see that the burglary occurred when the defendant unlawfully entered Mackenzie Brackman's house with intent to commit criminal mischief. Detective Markowitz also investigated this as well as she collected the cell tower data. And the video clearly shows the break and exit of the defendant to Mr. Brackman's home. The video also explains why no identifying traces were in the home. And pertaining to the alibi story, we have seen that Taylor Perkins would do anything to help out his or her best friend, and she also got impeached during this court meeting, and she's proved to be completely untrustworthy. And Professor Blake Van Owens, he has heavily demonstrated very sloppy research. He's failed to provide any real evidence for his theory about Blair Rowlands. He could have chosen to get the testimony from Blair Rowlands to support his theory for him, but he didn't. He instead got an extended utterance from his father. He also says the knife was stabbed in an upward fashion, yet this does not explain how the stab wound found by the autopsy report was downward. You can't stab someone like that and there's a wound showing downward. That does not make any sense at all. He also says that somebody leaving town referring to Blair Rowlands, would show that he showed that as evidence. Doesn't make any sense at all either. And the defendant also claimed, without any proof whatsoever, that the Alex Cifuentes texts were doctored. The entire defense case is built up on conjecture and speculation, but they have nothing to refute that the defendant was rejected from his team, flew into a rage, and extracted revenge on Coach Brackman. The prosecution requests that you return a verdict of guilty on both charges. And that's it.
Thank you. Redirect, or pardon me, closing argument for the defendant, please.
Yes, Your Honor. Garbage in, garbage out. First, let me remind you of the burden of proof that states that the prosecution must prove beyond a reasonable doubt that my client, Avery Becker, is guilty. I can most assuredly say that they have failed to do so. The case of the prosecution began with bad evidence that led to an incorrect conclusion. The investigation was flawed, leaving out key pieces of evidence and being inconsistent with the conclusions that they made. They even lost evidence, and yet they still pertained to accuse my client. They made a conclusion and then made the evidence fit the bias they already had in their minds. This is why we ask that you find the defendant not guilty. From Blake Van Owen, a reputable private investigator, you have heard that the case was rushed and the conclusion does not fit most of the evidence. Alex Cifuentes provided an unstable interpretation, making one-sided claims that he was best friends with Avery and that he got text messages from them claiming that he was enraged at Mr. Brackman when in fact, he was just apologetic. Cal Cusack created a deeply flawed investigation with a heavy confirmation bias that ignored clear facts and mishandled evidence. Avery lost his cell phone the day of the murder and spent the whole day with Taylor Perkins trying to find it. It wouldn't make sense for him to be both looking for his phone and to have it with him if he was trying to break into Brackman's house. Avery's lost phone wouldn't have been able to answer any of Taylor's texts, much less Alex's, which would have been less important. Alex Cifuentes is an unreliable source of evidence. It is entirely possible that he took Avery's phone and gave it to Blair Rollins to try to frame Avery, or even fabricated the text messages himself. Why would Avery text his greatest rival that he was going to break into their coach's house and not his best friend? It does not add up. The many inconsistencies in this case do not paint a clear picture of who did it. Once again, I would like to remind the jury who has the burden of proof. The prosecution must prove beyond a reasonable doubt that Avery Becker is guilty. The prosecution has failed to do so. They made a conclusion before the case was conducted, and with this bias, they cannot have made an objective conclusion based on the evidence provided. It is for this reason that we have proved that the jury must find the defendant not guilty. Thank you.
Is there any time left for a rebuttal close? Any rebuttal close?
Your Honor, if there is time left, I would like to make a very brief rebuttal.
You have about like 30 seconds.
That'll be brief. Let's see what you can do, Mr. Phelps. Go ahead.
All right. So really what we think that one of the very large things that came out of this trial so far is how unreliable the defense's witnesses are. We already talked about how unreliable Blake Van Owen is, how he contradicts, how his entire research makes no sense at all of the night, about how he can explain the plates, how you commonly drop plates and you don't clean them up. Also how how Perkins was impeached, and also how Avery Becker completely contradicted her own testimony during this trial. And we would like you to please.
Time.
Thank you.
Thank you, Your Honor.
All right. I assume,
Your Honor, excuse me. I have a question while we're scoring.
Yes, Ms. Gross.
I have a discrepancy on my score sheet between who I thought was defense counsel 2 and what is listed on the trial roster for the defense.
Okay.
And I'd like to clarify that before I score.
What you need, Ms. Gross, then is the name of the attorney who conducted the second examination for the defendant.
Yes.
All right.
Right.
Who conducted the second direct examination for the defendant?
I did.
Thank you. It was Ms. Gross. Do you have that? It's Ms. Mestis.
Okay. And did you? Okay. Thank you so much.
Anything else from any of the scorers? All right, I'm gonna let the scorers do their thing. If you guys don't mind, a few comments from me. I'm sure you're just tired of all this anyway. But first of all, would everybody give each other a hand? Come on, give yourselves a hand. This is hard work, and it's very impressive the amount of work that you do. As I said, I do a lot of advocacy teaching, and I started writing down specific comments and critiques for each one of you, and then realized that was silly because it's a waste of time, and we don't have time for me to do that. So what I'd like to do is give you some things that I saw more than one of you do that I think that all of you might find helpful. First things first, slow down. I recognize that you're under time crunches here, but learn to pace yourself. One of the problems that we get into when we are faced with time crunches is we tend to start talking really, really fast. And when we start talking really fast, it flattens out our vocal tone. And everything you say comes out at exactly the same, not just speed, but also the same tone. And you lose the ability to emphasize words, which is my second point. I'm a big believer in the power of pauses. It makes the people that you're listening to think about what you're doing. If you want the best example I can think of, ask questions where your question comes out like it was real, comfortable jeans, right? As if there was a period after each word in the question. I'm going to suggest to all of you that you stop using the word relationship in the context that you're using it. All right. What was the relationship between Mr. Becker and the coach? What was the relationship between Mr. Fuentes and Mr. Becker? Civilians believe, so lawyers use that word when they, in a way that civilians don't. Civilians all think that the word relationship means what? Don't have to answer that because you all know, right? But that's not what you're talking about. What you're really talking about is, tell us how Mr. Becker got along with his coach. All right. As opposed to what was the coach's relationship with Mr. Becker, which in a school context gets pretty creepy, right? So no, seriously, the word is just, you don't think about it that way. And lawyers do that all the time in courtrooms too. Don't preface things you're going to say by saying, I have a few questions, or I'm only going to ask you a couple of questions. No, you're not. Nobody wants to ask you, no one wants to talk a little bit about something. You all want to talk a lot a bit about something. But those phrases like that put false parameters, false fences around your questions. And in a real courtroom, if you go ask more questions than the jury defines as a few, they stop listening. So just say, I have some questions. I'm going to ask you questions, but don't say a little bit, a few questions, etc. Don't limit, don't create false parameters for yourself. When you're talking about exhibits, and this is one of my personal bugbears as both a teacher and as a judge, always call the exhibit by its name. None of you wants to be called hey you, and neither do exhibits. Exhibits all have names. And you know what the exhibits names are? Their exhibits names are Exhibit 1, Exhibit 2, Exhibit 3. So just, I'm showing you what's been previously marked as Exhibit 4. What is Exhibit 4? How do you know that Exhibit 4 is? When you look at Exhibit 4, what do you see? All right. But by doing that, you keep your record very clear. And so you don't have to say, what is this? What is it? Imagine a commercial case that a lawyer's doing where you have hundreds and hundreds of pages of text or messages, right? As opposed to saying, what is this message? The record's going to look like oatmeal. So identify exhibits. Let's see, be careful about clutter. As lawyers, and particularly when we're starting out, we use way too many words to say something. Your Honor, I'd like to move to admit Exhibit 4. I got to the habit by the time I was done, say, Your Honor, move the exhibit of Exhibit 4. as an imperative. You don't need all that. And the ones that are the worst for us when we're starting out are the words okay at the end of an answer and at the beginning of a question, right? Eventually, that will sound like water dripping to a witness. They're waiting to see how often you say it. The other thing, the danger with okay, particularly on cross-examination, is that you may sound like you're affirming something that you don't want to affirm. Be careful about discussing what's possible and what's probable. In real life, only probabilities are admissible or have any evidentiary quality, not possibilities. And particularly in a criminal case like this, when something has to be proven beyond a reasonable doubt, a possibility arguably is inadmissible if it's only a possibility. Be careful about asking argumentative or conclusory questions at the end of your examination. You get a good point from your witness and then you all go, so blah, 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 blah. That means, no, save that for closing argument when they can't contradict you. And several of you saw that happen to you. You asked a conclusory question at the end of an examination, right? And the witness proceeded to chew you up and spit you out because they just kept talking, all right? Let's see, we already did that. Be careful of asking did you, would you, could you questions on cross-examination. Or on direct examination. Did you do this? Could you do that? Yeah, the answer is, of course they could. So some judges will rule that did you, would you, could you questions, particularly asked too many of them, are leading, all right? Not everybody will do that, but don't thank judges for doing anything. All right, don't say thank you, Your Honor. You don't have to thank me for doing my job. All right. And by the way, Mr. Patel's laughing. I've said that. I said that to lawyers in real life all the time, including in front of jurors. You don't enter an expert. You tender an expert. All right. You don't enter. We move to enter Dr. Van Herbucket as an expert. No, we tender her as an expert. That's the proper phrase. Be careful about repeating direct examination on cross. There's no need to repeat direct examination. You're an expert in cell phone towers, right? Why? All that does is let the other side emphasize their points, and it wastes time. Cut to the chase. Let's talk about your education as a cell phone tower expert. You never went to school to do that, right? See what I did there? I didn't have to ask him, you've identified yourself as a cell phone expert. Why let them affirm it? Let's see. Watch out for non-responsive answers, which are notorious in mock trial, particularly in cross-examination. You ask a question and the witness wants to argue with you. If the answer is non-responsive, say so. Objection, Your Honor, the answer is non-responsive. And then move to strike it. It's a very controlling thing on cross-examination, by the way, to do that. One thing that struck me about closing argument, particularly because this is a criminal case, and I recognize that this is elbow room stuff. In a real criminal case, the defendant has no burden of proof, and to say anything that makes it sound like the defendant has a burden of proof in a real courtroom would get you a mistrial. For example, when in closing argument, the defendant did nothing to refute our evidence. The defendant has no duty to do anything. The defendant can sit there and play canasta through the entire trial if he or she wants to. They won't, but they can. All right. Defendant has no burden of proof. And then the defendant, though, did that too in the closing argument when defense counsel said, we have proved that the jury should find the defendant not guilty. No, you haven't proved anything because you don't have to prove squat. Just go straight to the issue of the jury should find the defendant not guilty. Okay. Ms. Kiefer, I like your potential green screen there behind you with your sheet. I'm not really sitting in that courtroom. That's a picture that my law clerk took before I retired, and I use it for things like this. When I started teaching my law school classes on Zoom back in March, my camera was pointed at the closet door in what's laughingly referred to as my home office, which is actually used to be called the smallest spare bedroom. But my division clerk said, why don't you try to find a sheet and hang it up behind you and you can use it for backgrounds. When I went through our linen closet, I found an old green sheet that no one was using. So I have a green screen back there that I didn't have to pay $300 for. I have a green sheet that's thumbtacked to the wall behind me. All right. I'm going to shut up now. Thank you so much for letting me do this. This is so much fun. And you all have all the potential in the world. And I want to remind you, I said that business about advocates, but I want to say something else. Do you realize that sometime in the future, someday farther down the road, some of you are going to get a chance to do exactly what's being done here with you? That you're going to get a chance to judge or score a high school mock trial when you're in law school or when you're out in practice, and some of you will become judges. Do it. You owe it to the people coming up after you. The law was here before me, and I'm old, and the law will be here way after you. But all of us have an obligation to protect and preserve the rule of law. And once we become lawyers, we have a specific obligation to do that under the Code of Professional Responsibility. We have a special, the preamble of the code says that lawyers have a special responsibility for the quality of justice. How about that? A special responsibility for the quality of justice. Live up to that responsibility. Thanks very much for your time.
Thank you for taking the time to judge us and then also critique us. I really appreciate that.
That's okay. Mr. Patel, believe me when I say, if I had the time, I would spend an hour with every one of you, having written down all the things I would tweak. But that's not my job. I'm not your coach. All right.
Thank you so much.
Hey, it's worth it to me, Mr. Phelps. You guys did a fine job. The stuff you were doing, you've got some good instincts, young Jedi. You've really got some. I'm sorry, I do that with my students too. You've got good instincts here, right? Now, you let in a lot of evidence that in a real life trial wouldn't have come in, and you could probably benefit from making a hearsay objection here and there. But I get Judge Madden, who helps design these problems. Judge Madden and I are dear friends. We're good buddies, and we're on the bench together, and now we're at jams together. I'm retired now, but I'm doing mediation and arbitration work for an outfit here in town. How many of you have parents or close relatives who are lawyers?
Not a close
Look
relative.
at all those hands, right? Anybody inspired to become that doesn't matter. It's okay, Miss Kiefer. You can be a lawyer even if you don't have a relative who is one. Are your relatives who are lawyers trial lawyers? Yeah, okay. Good enough. Have you ever gotten to watch, how many of you have gotten to watch a real trial in a real courtroom before all this ridiculousness hit? All right.
Mr. McKay, I think I might have come talk to you because we went on a courts field trip in 8th grade.
You did.
And I feel like I talked with you.
You've heard all this crap, haven't you then, Miss Burnham? I'm sorry.
Well, I recognized the courtroom behind you too.
You probably did. Where'd you go, MPB?
I went to St. Vincent's.
St. Vincent's, okay. Yeah. Yes, I love talking to young people. It's just so cool. Were you one of the people who got to sit in the jury box, Miss Burnham, or not?
Yes, I was.
Okay. When I bring folks in like Ms. Burnham's class, I tell them they can sit in the jury box, in which case everybody fights to get in the jury box because they want to be one of the people who sit over there. Then they realize how close they have to be to me. And then it's frightening. So anybody else have any questions? I don't want to take all your time. This is just fun for me. I'd sit here all afternoon and talk to you guys. But you probably, I'll bet how many of you answering the judge's questions in truth would like to really go get something to eat? I was lucky. My son brought me a cheeseburger and French fries while we were still having trouble getting locked into the room. So I've already inhaled a cheeseburger and French fries before that. Our dog came in and shared the French fries with me. So I had to. We have a Great Dane, and occasionally she decides to come in and say hello to everybody. Young Jedi, thanks very much. This was great. My applause to you. My props to you. I'm going to do one thing. All right. I'm going to give you my email address. And if anybody wants to talk more or confer more, I would be thrilled to do that. Okay. All you got to do is say, I was in your mock trial on Saturday. Can I ask you X? All right. Everybody ready? All small letters. Robert, R-O-B-E-R-T. Yes, Mr. Billings. Get your
In 1 second, I'm not ready. I have to find my thing to type it.
This is called a pen, Mr. Billings. People can use them to write things down.
You see, I don't have paper.
Mr. Billings, this is called a legal tablet. You can write things on it. Guys, I'm so old that I started practicing law before the existence of Kinkos or sticky notes. Okay? Look, the first thing I ask my students is if any of them were born before 1974, and none of them ever were, which means I've been practicing law longer than any of them have been alive. All right. You ready now, Mr. Billings? All small letters, R-O-B-E-R-T, Robert. Or pardon me, let me start over. Skip that. I was giving you I'm sitting here and looking at my old judge job and giving you my judge, and it won't work. All small letters, McGahey, my last name, M-C-G-A-H-E-Y, at. All small letters, JAMS, J-A-M-S, Denver.com. If there's anything you want to ask me, I'll be happy to chat. Believe me, I will. Because if there's anything I like to talk about, as much as I like to talk about real football, the kind you play with your feet, it's trial advocacy. I love this stuff. I never wanted to be anything but a trial lawyer. I didn't want to be an astronaut or a cowboy or a fireman. I wanted to be a trial lawyer. It was the only thing I ever wanted to do. And I was lucky enough to get to do it. So for those of you who want to do this, good for you. I'm going to shut up. I am acting like your grandfather who talks way, way, way too much, right? But grandpas are okay. Thanks, everybody. I'm going to get out of the meeting and let you go.
Thank you so much.
Anything else?
Thank you so much.
Thank you so much.
You.
Thank you.
Everybody, thank you.
Thank you.
Thank you.
Out you go.
Thanks, Judge McGahey. You're about to make me cry.
Oh, what did I do to make you cry?
You're awesome.
No, I'm just old and I've been at this a long time. It's just, no, what makes me cry is them.
Yes, yes.
It is. They are so eager. They are so excited. They are so raw. Oh God, they're raw. But if I could do anything to make them love trial work as much as I do, then that's my job. I just appreciate that I was able to do this. I can't always, but I'm always glad to be asked. So is today the last round, or is the finals are tomorrow, right?
And I'm sorry, I can't think of what the dates are for the state, but I believe they're in a couple of weeks.
But this was the last day for Arapahoe, right?
This is the last day for Arapahoe.
Okay.
So we're sending 4 to state.
Yeah. I'd be interested to know what teams get to go. Can
Okay.
I'm just curious too, and you don't have to tell me. Are you willing to tell me who teams H and R were, what schools they went to?
I sure can tell you.
I'm just curious.
H,
One will be St. Mary's.
H was Regis C.
Okay.
Regis C team, and R was St. Mary's B.
See, I was right about that. When at least one of the people, if you heard her, she came to my class when she was in 8th grade. And so I was reasonably certain that she'd gone to St. Mary's. I'm not surprised that Regis is involved. My oldest boy went to Regis. He was not at all invested in this. None of my children are lawyers, and none of my children should have been lawyers. Okay, you should only want to, no, you shouldn't be a lawyer if you don't want to be one. I mean, nobody should go to law school because it can't think of anything else to do. It's too much work. So, and thank you so much for all the work you guys do. Good Lord.
Well, this was a tough one to get used to, but hopefully we can meet in person next year.
I was lucky because I've been able to, but I've been teaching my law school classes on Zoom since March. I've actually done 2 or 3 semesters where all my final trials were on Zoom. So I'm not unfamiliar with doing trials this way, not with that big a group, but I'm used to it. And we do everything at JAMS. We do all our mediations on Zoom. So.
Oh, great.
This is great. This was great. Go home. Go do something that's more fun than this. All right. I know you guys have things to do at the end. You've got to still sit there and try to add up scores and figure out who's going to win and all of that. The nice part about this being sort of B and C teams,
right?
I may get to see these people again. That'll even be more.
Exactly. Well, we hope you come back next year.
Well, you realize that Judge Weishoffel guilted me into doing this. Not that I wouldn't have done it anyway, but I probably wouldn't have thought about signing up if Judge Weishoffel hadn't called me out. I'm sure you saw her email, didn't you?
I did. Yes. That was funny. No, thank you so much for taking your time.
That's okay. Gave my wife a chance to continue to binge watch whatever vampire show she's watching right now. So, okay. I watch this is true. I watch old episodes of Perry Mason, the old ones with Raymond Burr. Mm-hmm. And my wife binge watches vampire movies. She likes vampire shows. But together, what we watch are English mysteries.
Nice.
Binge watch them, and they're great.
Nice.
So there's her shows, my shows, and our shows.
And then, yep.
Take it easy.
All right. It was good to see you. Thanks again. We appreciate it.